Facts. In 1953, Anastasio Paciente, Sr. was granted a homestead patent over a parcel of land situated in Bangam, province of Cotabato. An original certificate of title number V2423 was issued in his name. By virtue of a deed of sale allegedly executed by Anastasio in favor of his brother-in-law Eliseo Bagaygay, the latter took possession of the subject land, transferred the title under his name, and later caused the subdivision of the entire land into three lots. Anastasio died in 1989, while Eliseo died in 1991. Eliseo's wife, Anisita, and their children, who are the petitioners in this case, took possession of the subject land upon his death. In 1999, the respondents, who are the heirs of Anastasio, filed before the RTC an action for declaration of nullity of the deed of sale and the titles, recovery of ownership and possession, accounting, and damages against the heirs of Eliseo. They allege that in 1956, Eliseo, taking advantage of the financial distress of Anastasio, was able to obtain the latter's title and take possession of his land. They added that Eliseo caused the cancellation of Anastasio's title through a fictitious deed of sale. Respondents added that assuming that there was a sale, the sale was void as it was executed during the 5-year period of prohibition under the Public Land Act. Respondents Paciente presented as witness the Registrar of Deeds to testify that the original of OCT number V2423, as well as the copy of the deed of sale executed by Anastasio in favor of Eliseo, had been lost and could no longer be produced. The Register of Deeds also testified to identify the primary entry book as secondary evidence and to prove that the deed of sale was executed by Anastasio on November 28, 1956, which is within the prohibited period under the Public Land Act. Petitioners refuted the date of execution stated in the primary entry book presented by the respondents. They testified that Anastasio sold the land to their father to defray the expenses for the wedding of his son in 1958. To corroborate these testimonies, petitioners submitted as evidence the marriage contract of respondent Mary Hildo, showing that the latter was married. On June 8, 1958, the RTC dismissed the complaint for lack of merit. It gave credence to the testimonies of the petitioners that the sale was made in 1958 and not 1956, and therefore outside of the prohibited period. On appeal, the Court of Appeals reversed and ruled that since a copy of the deed of sale was no longer available, the date indicated in the primary entry book of the Register of Deeds of South Cotabato as the true and correct date of execution of the deed of sale. Hence, it declared the deed of sale void ab initio, having been executed on November 28, 1956, or within the 5-year prohibitory period. The issue in this case is whether the Court of Appeals seriously erred in not ruling and applying the principle of laches on the part of the respondents. Ruling, no, the Court of Appeals did not commit an error in refusing to apply the principle of laches. In the heirs of Alido versus Campano, the court made it clear that laches does not apply to void ab initio contracts. In heirs of Injug Tiro versus Spouses Casals, the court expounded that laches cannot prevail over the law, that actions to assail a void contract are imprescriptible. It being based on equity. To wit, in actions for a conveyance of property predicated on the fact that the conveyance complained of was null and void ab initio, a claim of prescription of action would be unavailing. The action or defense for the declaration of the inexistence of a contract does not prescribe. Neither could laches be invoked in the case at bar. Laches is a doctrine in equity, and our courts are basically courts of law and not courts of equity. Equity, which has been aptly described as justice outside legality, should be applied only in the absence of and never against statutory law. The positive mandate of Article 1410 of the new Civil Code, conferring imprescriptibility to actions for declaration of the inexistence of a contract, should preempt and prevail over all abstract arguments based only on equity. Thus, no error was committed by the Court of Appeals when it declared the deed of sale executed by Anastasio void ab initio.